In the meantime, let's now get some legal analysis on this judgment. We're now joined via Zoom by attorney from, Makangela Mtungani Incorporated. A very good morning to you, Mr. Makangela. Thank you so much for joining us. How do you find this decision by the Constitutional Court? Simply break it down for us, if you can.
Good morning. Good morning to the viewers as well. Now, this matter is settled. Now it is law. The majority, as we all know, that it has made its own ruling, but what the former president wanted was it to reconsider its position, to say it did not consider some of the issues, in that he was convicted without him being afforded a fair trial, as envisaged in the Constitution. Now, when you are saying you are rescinding a judgment, you are saying there are factors that if they were brought to your attention, you would not have made a particular finding. So Justice Kambebe says all the information that he is bringing, it was there before the court, it was there before the majority of the judges when they made their finding. They see no reason why they should change from that position. In actual fact, because he's bringing the application in terms of two grounds, that is Rule 42 of the Uniform Rules as well as common law. Now, the majority judgment says he did not make out a case to meet the grounds for him to succeed in terms of Rule 42. As Justice Kambebe said, that there is nothing new. Instead, all what he did, he created this chaos for himself. Again, on common law grounds, there is no good cause, because all what he wanted to say, he ought to have said it in the contempt proceedings, of which he elected not to. So he cannot just bring them now and try to resuscitate a case that he ought to have made in the contempt proceedings by bringing a rescission application. But of course, again, the minority judgment, that is Justice Jafta together with Justice Theron, maintain their position. They say, well, the Constitutional Court has an authority in terms of Section 172 of the Constitution to reconsider its position. The judgment that it has made, it is even flouting those international instruments that have been referred to, those articles that guarantee the human rights, that protect the rights of every citizen. So they say nobody can be convicted without being afforded a fair trial as envisaged in the Constitution. Well, according to the minority judgment, they say, well, he ought to have been subjected to a trial where he must plead to a crime of contempt. Because they say this process, it's a hybrid process, but it never afforded him an opportunity to plead to a charge, because the charge must be put to him, he must plead to it, and then the process where he gets to be convicted is afforded an opportunity to say, you must respond, you are in contempt, this is what you are likely to face should you be found guilty of this contempt proceeding.
Now, Mr. Makangela, please hold your thought. We'll come back to you in just a moment. That was attorney, Sinawo Makangela. And that is Makangela. Yeah, he's been giving us a legal overview of what the case is all about. And as soon as we have reestablished the line to Makangela, we'll be touching base with him. But for now,